Be ready. Start. But in the case of section 27(3), law is totally devoid of any guidelines and no exceptions have been carved out. It is common ground that the said amendment of section 27 was brought about in 1988, which was much after the Constitution of India has come into operation. The Parliament, while making law, has to function under the specific mandates of the Constitution. Apart from the restrictions imposed on distribution of legislative powers under Part 11 of the Constitution by Article 245 onwards, the direct mandate of the Constitution under Article 13 is that the state shall not make any law which takes away or abridges the right conferred by Part 3 of the Constitution, and any law made in contravention of the same is, to the extent of contravention, void. It is obvious from the aforesaid that Article 13 2 clearly prohibits the making of any law by the state which takes away or abridges rights conferred by Part 3 of the Constitution. In the event of such a law being made, the same shall be void to the extent of contravention. It is obvious that only the judiciary can give the declaration that a law being in contravention of the mandate of Part 3 of the Constitution is void. Therefore, power of judicial review is inherent in our Constitution. Article 13 of the Constitution is therefore a unique feature in our Constitution. On a consideration of the various circumstances which we have mentioned in this judgment, we are of the opinion that Section 303 of the Penal Code violates the guarantee of equality contained in Article 14, as also the right conferred by Article 21 of the Constitution that no person shall be deprived of his life or personal liberty except according to procedure established by law. The section was originally conceived to discourage assaults by life convicts on the prison staff, but the legislature chose language which far exceeded its intention. The section also assumes that life convicts are a dangerous breed of humanity as a class. That assumption is not supported by any scientific data. There is a popular belief that prisoners serving a life sentence after conviction of murder form a specially troublesome and dangerous class. That is not so. Most find themselves in prison because they have yielded to temptation under the pressure of a combination of circumstances unlikely to recur. The court has to exercise its discretion in the matter of life and death. In the opinion of the learned Chief Justice, any sentencing process by which the legislature deprives the courts of their legitimate jurisdiction to exercise their discretion not to impose the death sentence in appropriate cases and compels them to shut their eyes to mitigating circumstances is unconcisable. The other class of cases in which the offense of murder is committed by a life convict while he is on parole or on bail may now be taken up for consideration. A life convict who is released on parole or on bail may discover that, taking undue advantage of his absence, a neighbor has established illicit intimacy with his wife. If he finds them in an amorous position and shoots the seducer on the spot, he may stand a fair chance of escaping from the charge of murder, since the provocation is both grave and sudden. But if, on seeing his wife in the act of adultery, he leaves the house, goes to a shop, procures a weapon, and returns to kill her paramour, there would be evidence of what is called mens rea, the intention to kill. And since he was not acting on the spur of the moment and went away to fetch a weapon with murder in his mind, he would be guilty of murder. It is a travesty of justice not only to sentence such a person to death, but to tell him that he shall not be heard why he should not be sentenced to death. And in these circumstances, now does the fact that the accused was under a sentence of life imprisonment when he committed the murder justify the law that he must be sentenced to death? In ordinary life, we will not say it about law. It is not reasonable to add insult to injury. But apart from that, a provision of law which deprives the court of the use of its wise and beneficent discretion in a matter of life and death without regard to the circumstances in which the offense was committed. Thank you.